Welcome to today's program titled Updates on California Pay Reporting Requirements. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to Annette Timon. Annette, please go ahead.
Thank you so much, Kelly, and welcome everybody to our webinar today that is holding an incredible amount of interest in light on the impact that it's going to have on future reporting requirements for those employers that have operations or employees in California. So I wanted to begin by introducing my colleagues on this team. So as Kelly said, my name is Annette Timon. I am the co-chair of the People Analytics Group. And as a result, in our team, we handle a lot of pay reporting type of obligations, including the requirements that are going to fall under the California Pay Reporting Act. I am joined today by Mike Childers, who is an associate on our team, as well as Sharday Scahan. We're very excited to begin rolling out and kind of finally answering some of the key questions that certainly we have been getting. As you may know, the agency just provided what we believe is to be close to final guidance so that employers can really kick off and launch into this next phase. And I'd like to begin with an overview before we kick it off to Mike and Sharday to begin spelling out some of the details. So what is it that we're here to talk about, right? This is the State of California enacted a pay data reporting requirement that is going to be submitted to the Department of Fair Employment and Housing. And it's essentially going to collect pay and hours by establishment, job category, sex, race, and ethnicity. It is very similar in some ways to, for those of you who would have completed the EEO-1 pay reporting tool for 2017 and 2018, we refer to that as component 2. So it has, basic information about EEO-1 data, including, workforce demographic information, but this element brings in an additional component which has to do with pay. Like I said, in some ways similar. And we're going to try throughout this presentation to give you important call outs that are different. And when we refer to, important EEO-1 differences, we're talking about component 2, because so many employers went through the process of setting up their systems and setting up their data in order to collect component 2. And we want to be able to at least identify those areas where we're seeing differences. That deadline is fast approaching. So, today is February 4th. We just got some updated guidance that was, I think, really critical on Monday. There are some guidance materials. So there's some FAQs, and the agency has been streaming those FAQs, rolling them out. But many of the final components, and I would say some critical pieces of information, were provided on Monday. So there's not a lot of time. There's also a user guide that employers can use to understand a little bit more about how the sort of technical components are going to look. What does the portal look like? What is the Excel file or the CSV file that you're going to use? How does that actually look in practice? And it's going to give you some more technical guidance and information. That pay reporting portal, or the method for which you're going to transfer your data, is going to be available on February 16th. So we still have a little bit of time here to actually see what that portal is going to look like. And we're going to do our best to provide as much information as we can so you're not waiting until the 16th to start gathering it. I wanted to preface one key difference that at least based on our read that we're seeing, which hasn't been outlined, at least explicitly, by the department. And that is that for those of you who are familiar with filing EEO-1 data, what typically happens is, if you're part of a subsidiary or a corporate enterprise that has, a parent and subsidiary organizations, typically those are filed as one complete filing. The way the EEOC for EEO-1 purposes defines it is essentially, if one company is owned in majority, has majority ownership over another corporation, those should all be filed together. The California guidance is not as explicit, but it does specifically say that a pay data report covers only a single employer, and that underline under single that we have on our slide is from the materials that they've provided. And then when we look at that plus the Excel spreadsheets and how you're supposed to put that information in, it appears as though employers with, parent organizations, subsidiary organizations, affiliate organizations would not be filing one complete report. It would be every one of those employers or separate employers would be filed separately. I wish I had a more definitive answer. We do have a message out to the department, and we will try to put some guidance out if we get any additional information, but we wanted to highlight that as a potential quite significant difference that we see. So with that, I'm going to go ahead and turn it over to Sharday, who's going to kick us off and talk a little bit more about who exactly must report.
Thanks, Annette. So one of the first things you want to look at is whether you are even encompassed under this new law, and 100 is the magic number that you're looking for. So you either need to have 100 or more employees employed during the snapshot period, and that's going to be between October 1st and December 31st of the reporting year, or you're going to have 100 employees employed on a regular basis. Now, when you're considering the 100 employee threshold, there are a number of employees who are going to be qualifying for the count under California's law. So that's going to include employees who are employed outside of California. It's also going to include part-time and temporary employees if they're on the employer's payroll. And then also it's going to include employers owned or operated by affiliated with another company. So really, this is super, super broad. You're counting all of your employees throughout the country instead of just your employees who are working in California. And then for the 100 employees on a regular basis threshold, say you're a seasonal employer, and so really your season is 4 months long. So the DFEH is going to look at whether you employed 100 employees regularly during your season as opposed to throughout the entire year, because when you're off season, maybe you only had 50 employees. So if you are a seasonal employer or have other unique circumstances like that, the DFEH is going to consider whether you had 100 or more employees during your main working time. It's also going to apply if you are required to file the EEO-1 report, and then you have to have at least one employee living, working, or assigned to a location in California to have this reporting obligation. And we're going to discuss that in a little bit more detail. On the next slide, you will see that there are a lot of considerations, but everything that you want to look at is, are there ties to California? That's how you're going to figure out whether or not these employees need to be included. Again, this is going to be very broad. There's no size limitations under California's law. So if you have an employee who works in California, that employee is going to be included on your report. If you have an employee who is assigned to a California location, whether or not they're actually physically working in California, then that employee will also be included in your report. So say you have an employee who is technically assigned to the Los Angeles location, but they're really working at a client site in Dallas. Well, that employee is still going to be included in the report because they are assigned to a California location. And then the last category will be employees who live in California, again, even if they're reporting to a location outside of California. So maybe this employee is reporting to a Minneapolis site, but they're living in San Francisco. So that employee is also going to be included simply because they are living in California and that's their ties to the state. So you want to look at, are they working in California? Are they assigned to a California location? And are they living in California? If one of those conditions are met, then that employee is going to be included. And for the employees included in the report, it's only going to be employees who are employed during that snapshot period that you select. So again, that's October 1st through December 31st. If your employee was on the payroll during that period and meets one of those conditions with the ties to California, then that employee is going to be included in the report. You also are going to be including each employee separately by establishment. So your company may have multiple different establishments in California or in other states. So you'll see when we go through some of the examples and when you take a look at the user guide, the DFEH really wants you to break down the locations of your employees by establishment to get into the specifics. So that employee should be included for the establishment to which they are assigned. So that might mean that you have an establishment that's not a California establishment, but it is included in the reporting obligation because you have an employee with ties to California who is assigned to that establishment or living in California or working in California, et cetera. So that's something to consider too, that you're not only looking at your California establishments, you have to look at which employees have these ties to the state of California. On the next slide, we're going to go over a quick example for companies that might have multiple establishments. So in this example, our company, Acme Inc., they have 295 employees total. And you'll see that we've split the employees in various ways. They have 200 employees who are physically working at the 123 Main Street Avenue or Main Street location in San Francisco, and they're also living in California. You have 20 employees who are remote working. They're living in California, and they are technically reporting to that 123 Main Street address. You have 73 employees who are physically working at a different establishment at 456 State Street. And then you have one remote worker living in Illinois, but reporting to that State Street address. And then you have one worker who's physically working in Reno, but living in California. So all of these employees are going to be assigned to these various establishments. For that 123 Main Street establishment, that's going to include all 200 employees who are physically working at the location, as well as the 20 employees who are remote working. They're living in California, but they are reporting to that 123 Main Street. So those are the people who are going to be included for that establishment. The next establishment will be the 456 State Street address. So that's going to include the 73 employees who are physically working at that address. And it's going to include that one remote worker who's living out of state, not living in the state of California, but they're reporting to that State Street address. So for the second establishment, you have those two categories that are included. And then finally, at the, oh, yeah.
No, go ahead when you're done.
Okay, finally, at that Reno address, you're gonna have that one employee who is physically working at the Reno address, but since they're living in California, they're included under that Reno establishment because they're living in the state of California, even though they're not assigned to or working at a California location.
I just wanted to add, because I'm seeing questions coming up on this issue. So this is one of the FAQs provide that, okay, these are, in this example, there would be 3 establishments that you're actually going to be reporting on. So what happens if you have other employees at that Reno location, right? So who do not live in California, but you have other people, either they're reporting from other states to the Reno location or they're physically working there. You do not have to report on those other Reno non-California employees. So I know that there were some questions coming up on that. So you don't have to. The FAQs provide that employers may do so. but not required to do so. So that would mean you're going to have to make a decision as an organization if you can easily remove them, and understand that, there's some privacy considerations, which we're going to get to in just a moment. But if you don't report on anybody else, and we're not providing legal advice here, but there's one employee, you'd be providing comp and hours information to California for just one single employee. That's a very big difference from how EEO1s are working. But I just wanted to address the don't work in California and don't report, don't work or live in California, do I still have to report? So that answer is no.
Thanks, Annette. So on the next slide, we're going to talk about how you're going to be reporting where is information going. So as Annette mentioned earlier, the portal is going to be available on February 16th. So it's going to be available pretty soon. We have screenshots via the user guide to get a look at what the portal is going to look like. But we know that there are going to be various options for you to input your data. So you can provide your data to the DFEH by uploading it or by inserting it into a fillable form. The DFEH recommends using the upload option, and that generally is probably going to be easiest because you can use a CSV file or an Excel spreadsheet to input all of the information that you have, and it will make it very easy to edit as necessary before you're uploading it. But there is an option to input it into a fillable form on the website if that's what you choose to do. Again, as Annette mentioned, each report is going to cover only a single employer. And for the multi-establishment employers, all of the establishment level data is going to be included in a single report. And this is different than the information that we were provided previously, which stated that you were going to have a couple different types of reports. There's no consolidated report now. It's just everything is going to be included in this single report. So the report has to contain the information for each location with the reportable employee, and we'll talk about that a little bit more later. And that includes locations where there's only one employee at the location. So as Annette mentioned on the last slide, for that Reno location, there might be only one employee who technically should be reported because that person's living in California. So for that Reno location, that might be the only person who you're going to report if you are choosing to only report on the people who are required. And another difference with the EEO1 reports is there's no type 6 reports in this instance. So there's going to be no limitation on your establishment size, and there's no establishment list that's going to exist if you have fewer than 50 employees, for example. So whether you have one employee at the location or you have 200 at the location, if they have those ties to California and meet all of the requirements, those people are going to be included in the report. The reports must be filed by March 31st. Haven't heard anything about any extensions at this point. So as of right now, you should be operating on the assumption that the reports are going to be due on time on March 31st. On the next slide, we will talk about what information must be reported. So there, as you see, there's a few categories that are laid out on the slide as far as how employees are going to be grouped. Remember, you're reporting on all the employees who are meeting the criteria that we discussed on the previous slides. Within that, you're going to group the employees by job category, pay band, ethnicity, race, and sex. And for sex, there is a kind of unique factor with the DFEH requirements that's also going to include non-binary if that's how the employee is reporting their sex. So, and for the pay bands, we're going to cover that in more detail in job categories as well. But within these groupings, you might have 5 employees who meet all of these same categories, or you might have 200 employees who meet all of the same categories. So you're going to be grouping each category based upon all of these factors that you see. So it's really going to vary depending on how many people you might have in a category that meet all of the other same criteria. So the group sizes can really vary. Within these employee groups that you're going to create based upon what your workforce looks like, you're going to also be reporting the total number of employees who are within that grouping and then the total number of hours worked by all of the employees within that grouping as well. All of that is going to be input into that Excel spreadsheet that you'll complete and then upload for the reporting. Now I'll turn it over to Mike. Oh, Mike, I think you're on mute.
Technology, yay. Thanks so much, Sade, both for the great introduction and also for letting me know about my technology failings. So this slide 10 is an overview of the employer-related information that you're going to need to provide on the California Pay Data Report. And there are two real categories of information we're going to be providing, and we're going to walk you through both of them. One is the employer-related information, and the second is the establishment and employee-related information. So a lot of these employer-related information data fields are very similar to what you've been providing on the EEO-1 report. So you'll notice snapshot period dates, you'll notice information about the location. But there are a couple of these that are new and that might take you some time to track down. So as with the consistent theme of this webinar, we advise you to get working on this sooner rather than later. And the ones that I really want to call out for you, you need to be able to provide not just your federal employer identification number, but also your California state-issued employer identification number. You also need to be able to provide whether or not you're a contractor doing business with the state of California. And you need to be able to provide not just the number of locations and number of employees within California that you're reporting on, but also the number of establishments that you have throughout the entire U.S., whether or not you're reporting them to California, and the number of employees that you have throughout the U.S., whether or not you're reporting them to California. So a little bit broader of a picture that you're required to provide in addition to those same fields for California specific. One other big call out that we want to make are these questions around whether or not the employer that is filing is owned, affiliated, or part of a broader enterprise. So as Annette and Sade have both said, these reports are being filed for single employers. However, the department wants you to identify whether or not you as a single employer are owned, affiliated, or part of a broader enterprise with other employers. And as part of that, they also ask, though this is not a required field, they ask that you provide the information about your parent company, and they ask that you provide any FEIN numbers for affiliated entities within the enterprise. Again, those are not required. However, those are pieces of information that are being requested by the department as part of the submission. And on the next slide, we're going to talk about the employee and establishment level information that you're required to provide. And a lot of these are similar to the EEO-1, right? We have establishment information, we have EEO-1 job category, race, ethnicity. Where the changes start, and Sade already mentioned this, are sex. So to the extent that you as a company already collect this information, if non-binary information is provided, you are instructed to report employees as non-binary the same way that you would report employees as male-female. So if you think about this as a fillable grid, there are now three gender options across. There's male with all of the associated races, there's female with all of the associated races and ethnicities, and there's non-binary with all of the associated races and ethnicities. So it's actually more data boxes than we're used to with the EEO-1. The next change is we're not using W-2 Box 1, which is what we were using for the EEO-1 Component 2. We're actually using W-2 Box 5. Which is your Medicare wages as opposed to your Box 1 wages, and we're going to go into a little bit more detail on that coming up. The second major change, we're still doing hours worked. However, it's now hours worked plus any PTO or non-working hours that were paid. for non-exempt employees, this is still the kind of thing that you would calculate based on timesheets or based on punch-in, punch-out data. For exempt employees, again, the timesheet or punch-in, punch-out data method of reporting is available to you to the extent that you actually track that for exempt employees. However, if you're not doing that, there's a California-style proxy calculation that you can do that, again, we're going to get into a little bit more detail on. So on the next slide, we're going to talk a little bit more about the Box 5. So as I said, we're no longer using Box 1. It's now Box 5, the Medicare wages and tips. And the important things to consider here are, just like with the EEO1 component 2, we're not annualizing. It is whatever is in that box for the employee, that is what is being used to slot them into pay bands, even if they were only with the company for a partial year, and therefore will be, slotted into a pay band based on partial year wages as opposed to full year wages. That's how we're instructed to do it. There are going to be some categories of employees, certain types of visa workers, that may not have Box 5 wages. If that's the case, you're going to use Box 1, and in the comments or remarks field for that grouping, you're going to note that there were some employees who were reported with Box 1 wages as opposed to Box 5 wages. The other big change that we're seeing here is there is an obligation, according to DFEH, that if somebody is issued a corrected W-2 and that corrected W-2 changes what pay band the person would have been slotted into, they are requesting that you file a new pay data report and note in the remarks field what has changed between the old pay data report and the new pay data report based on the corrected W-2. So this is a big change. With component 2, there was no obligation to update and keep current based on corrected W-2s, but that is part of the California pay data report. And you'll see here at the bottom, we've provided the pay bands that you're going to be slotting people into based on those Box 5 wages. These pay bands are exactly the same as the ones that were used with component 2. They're set by the Bureau of Labor Statistics, so they're kind of well known to all of us who were part of the component 2 filing saga. And so next, we're going to take a look at we're going to take a look at the hours component. Great. So as much as W-2 is very similar to what was happening with component 2, the hours component is really different. So any of you who worked on component 2 will remember the frustration associated with having to go through and figure out which of these are hours that an employee worked as opposed to these that were hours that an employee was paid. Nice enough, the California report, though it titles it hours worked, we actually think of it as time paid. And so for those non-exempt employees, it's going to be the combination of whatever hours they were physically on the job, plus any hours that they were paid for things like vacation, things like holidays, things like sick time. And you're going to total all of those up based on punch in, punch out, and based on timesheet. For exempt employees, as I mentioned, you can do the same kind of calculation that you did with non-exempt for the exempt employees to the extent that you track that information. However, our experience has been that the vast majority of employers don't track kind of punch in, punch out, or timesheets for exempt employees. So California has introduced their own version of the proxy calculation. And you might remember for the EEO1, exempt employees that when you were doing the proxy calculation were calculated based on their average number or their number of weeks worked multiplied by 20 hours a week if they were a part-time employee and 40 hours a week if they were a full-time employee. Those were your only two options. You were either a 20-hour person or a 40-hour person. California is focusing a little bit more and is asking that part-time or full-time calculation be done based on the average number of hours that the individual employee works within the year. So if you have somebody who works 20 hours, you would multiply their weeks worked by 20 hours a week. Somebody who works 35, it would be 35 by the number of weeks that they've worked, and 40 would be 40 by the number of hours of weeks they worked. And similar to component 2, again, we're reporting aggregated hours worked for everybody that's within the report. And the same goes true for the first section of this. We're reporting aggregated head count for everybody who falls within a group, and then aggregated hours for everybody that falls within a group. So if we can go to the next slide, we'll actually get to see kind of how this looks a little bit in practice. So once you have assigned employees to within the establishment, you're assigning them into groups based on job category, based on the pay band that you slotted them into, based on those W-2 Box 5 wages, based on race, ethnicity, and based on the sex of the employee. You're then reporting the total number of employees within each establishment that fall within those same job category, pay band, race, ethnicity, and sex groups. And then you're also reporting the total number of hours worked for everybody who's within that group. So if we take a look at the example here, if you look at starting at the 7th column, we've got our job category, and you'll notice that we've got different lines for each job category, race, ethnicity, sex, and pay band combination that occurs. And then we report the total number of employees within that pay band, and we report the total number of hours for employees within that pay band. So let's say, for example, that you have 3 African-American female professionals within an establishment, all of whom are working 40 hours a week. In that total number of employees column, you would report 3, and in that total hours column, you would report 2080 times 5 or times 3, so 6,240 is what you would report in that total hours column. And with that, I'm going to turn it over to Annette because we have a couple of individual considerations that we want to talk to you about because they may change your reporting obligations and how you go about reporting just a little bit. And before turning it over, I have the CLE code for everybody, which I know you're also excited about. So the code is SS7394. That's SS is in Seyfarth Shaw, 7394.
Okay, so I had, am I on mute still, or can you hear me?
We can hear you.
Okay, thanks. So a few considerations. I've been trying to answer some questions that are coming up, but and we'll try to keep doing those. We'll get through the next couple of slides, and then we're going to turn to. There's a lot of questions coming through, so we want to try and get those responded to as much as possible. So a few considerations. One has to do with PEOs. For those employers that are PEO, professional employer organization employers, there's a section that you're going to want to read in terms of the FAQs that just came out. I think a key difference from EEO-1 filing is that a PEO cannot submit reports that include multiple employers. And in the past, at least in my experience, the PEOs would typically file one under their name and include the data for all of the different employers. That is not the case under the California pay reporting tool. So you're going to want to take a look at that and revisit it, you know, very quickly with your clients. The same is the additional component that you're just going to have to figure out logistically how you do it is that, you know, you can submit the reports for each of the companies, but the company that itself has to certify the accuracy of their own report. So you'll have to figure out how to do that. At the end of the day, employers, if you work through a PEO, ultimately the responsibility for doing the filing is with the company. So the actual employer, not the PEO. There might be some contractual considerations that, you know, as part of the contract, the services that the PEO provides. But if you work through a PEO or PEO those, working on behalf of your employers, these are, pretty, I think a pretty a big lift and a difference in terms of how reporting works for PEOs. So make sure you take a close look at those. And then we can move to our final, oh, no, we're going to talk about, go ahead. Yeah, you can go to the next slide. Mergers and acquisitions a bit. So, it's very, the way the agency has basically put it out is when you think about, Sharday started talking about the snapshot period. So your starting point whenever you're doing this analysis is you are thinking about what's the snapshot that I'm going to select. It's the particular payroll period. That payroll period can be any time between October 1 and 12/31 of that year. So if you've got a merger that occurred, an acquisition that occurred in a given year, what you're going to be looking at is what's the timing, right, of the reporting period. The company that owns the employees at the time of the snapshot has the reporting obligation. That's essentially how the requirements are coming out. You would report, so let's say the merger occurred in June of 2020, and you've selected November 1 is your selected payroll period. So those employees, company A that they've merged into owns those employees as of November of 2020. You would just be reporting for the time period where you have the data. So once they joined you going forward. So those are the folks that you're going to be reporting on. So you have that reporting obligation, and if they weren't on your payroll for all of 2020, you're still going to report for them. And as of the time of filing, so let's say they merged off, but in November you had them, but by the time the time of the filing in March of 2021, when you actually do the filing, they're no longer part of your organization. You still have the reporting obligation because you own them essentially on the selected payroll period date. If you have the pre-acquisition information, you can certainly file it if you have it. But if you do not have it, then you just go with the information that you do have. You should put in a remark in the information that you're providing to the agency. There's an opportunity for you to include remarks on it as well. So if we go to the next slide, we'll talk about some data privacy issues. So this is a really important piece of information and an important takeaway to understand. This is going to be similar to the EO1 report. So there's no, for this document, there's no equivalent, kind of FOIA type of procedure. For purposes of the report itself, it can only be disclosed during an enforcement proceeding. So if you've got litigation going on, then potentially this information could be provided to a litigant, but it's not like OFCCP has access. If you're a federal contractor, you're aware that, anybody essentially almost can issue a FOIA request to OFCCP and get access to your EEO1 data. So this is more aligned with how the EEOC has to treat your information. It's not supposed to be made available prior to the institution of an investigation or an enforcement proceeding. But there is that, that information might be shared in that specific circumstance. What is the agency going to do with this information? I get a lot of questions about that. It is, to our understanding and based on what they have put out, they have said that they may publish aggregate reporting data. They haven't said beyond that how they're going to use the information. EEOC had suggested they were going to use it to engage in assisting in their investigations. They talked about running statistical tests. The DFEH has been silent on that specific information, so we really don't know how they intend to use it other than potentially publishing aggregate information. one key distinction that both I think Sharday and Mike have talked about is that, there is no minimum size for a particular establishment. So you can have, one employee reporting. It doesn't have the 50 employee threshold that the EEO1 reports do. So, you could actually have only one employee that is out there. You should definitely, if there's a request that has been received for this information, you should contact your legal department and outside or on-site counsel, whoever you use, for assistance in terms of how you respond to any requests that come for this particular data set. So with that, we'll go to the next slide and talk about some takeaways, and then we'll get to some questions that are out there. So, there's a lot of information that we've gone through, and I know we've gone through it pretty quickly here, but really it's so important to have a comprehensive plan for how you're going to complete it. It is different from from component to EEO1, and in our view, I think we think it's more onerous in terms of how you're going to report it. Some of the caveats or takeaways that the agency has, they did try to make it align somewhat to the EEO1 report. But it is more onerous in that you're not just reporting on California employees. There's kind of spaghetti bowl, and I've gotten lots of questions about what does it mean to be assigned and things like that. So we'll try and clarify those a little bit to the extent that we can. But some other things that you should be doing if you haven't done already, you're supposed to be, for example, using the EEO1 codes that have been used over the years. Just make sure that that information is accurate. Are you assigning employees to the right EEO1 category? Just because somebody is a project manager, do you have them in? Are they true managers where they would be in the manager category, or they should be in the professionals category? Take a look at those kinds of things just to make sure that you're aligning those correctly. Take a look at your high-level management groups. Look at your professionals. Look at the definitions that the EEO1 category has provided to make sure you're providing that information correctly. Make sure you have the exempt, non-exempt status information correct in your system so that you know which category in terms of how you're going to be reporting them from an hours worked perspective is going to be laid out. And obviously you want to make sure your pay is accurately being, captured, and that you're pulling from the right data source. That W-5 wage information is different. So you're going to need to coordinate, especially with those who have already built the code, built the, the information to capture all that data from component 2. Get these FAQs and get the information in front of them as soon as you can so that they're aware of the nuance and can adjust the codes. What we're hoping is that a lot of that information can still be used, but the logic is definitely going to need to be changed. So you're going to want to make sure you've got that. And then I guess the final takeaway would be to make sure that senior leaders of the organization and legal are involved in this process. They understand that, pay data information. We just had the, EEO1 collect 2 years, but then they've stopped that. Excuse me, the EOC collect 2 years worth of data, but they've stopped doing that. So make sure that they are aware of this reporting obligation, which is new, and it's going to, continue on. Make sure that you're conducting your robust pay equity analyses. And there's lots of reasons to do that. This is just another reason to make sure that you understand your pay, because I can tell you, we're talking about reporting obligations, but the data that you're providing in the format that you're providing will actually say nothing about pay. That's just, I'm going to make that statement. You can't compare everybody who is a professional. Just think of all the jobs that might be across, everybody who's listening in. We've got quite a few employers. Just think about all those employers and professionals, and just that grouping alone, that you can't really compare them from a pay data perspective. So it's really important to understand what your own data says about your compensation and how that's different. What does this report say? What does it mean? Because especially if this is in front of a potential litigant and they're asking questions during a deposition about what the data means, you're going to want to understand that as an organization. So we would strongly encourage you to continue to engage in your own pay equity analyses. Again, we would recommend doing those under attorney-client privilege, and making sure that you've got a comprehensive structure in place so that folks understand the plan and the timing implications as well. With that, I'm going to try and kind of on the fly here do as much as we can on the on the questions that have been coming through. I've been, like I said, trying to respond.
And that one question we've been getting a lot that I think will probably be helpful for us to build upon has been the question of, so if I'm a subsidiary and I have under 100 people, but the parent plus the subsidiary plus any other maybe affiliated companies combined, we have over 100 people. Do I have a reporting obligation? And the answer to that is yes, to the extent that you have employees in California. Let's
clarify that a little bit, just because it's yes if you're part of a centralized ownership, control, and management. So if you've got any of those sort of, you're working in central control of personnel policies, the group essentially constitutes a enterprise. There's a specific FAQ on that. In that case, then yes, Mike is absolutely right that you're all in it together for purposes of the threshold count. Now you're still filing separately, but
the report that you'll file is just for yourself, not for everybody else that's in the enterprise, with the caveat of those questions related to the parent organization, if you choose to provide that information. That would obviously be beyond you. The other big question that we've gotten is with respect to staffing agencies, and what are my filing obligations for people that I place at client sites. And similar to the EEO-1, the obligation is going to rest depending on where that individual rests on payroll. So if they sit on your payroll, you have the obligation to file for them. If they sit on the client's payroll, they have the obligation to file for them. And in terms of how you would file, the EEOC has issued a clarification guidance on this. I don't believe California has issued similar clarification guidance. The EEOC says that you can use either the client site address or the company's address where that individual ultimately reports into. We haven't gotten, to my knowledge, similar clarification for California. So as of right now, our advice would be, or at least my advice would be, to file based on the company's location where that individual ultimately reports to, or where employment decisions about that individual are made.
Great. So we're also getting a lot of questions about stores or locations with less than 50 employees. If they are in the state of California, you would be creating one for each establishment that you have. Establishment is defined. I mean, we sort of look at it from the standpoint of an address. There's a technical terminology. I don't know that I'll be able to put my hand on it right now, Mike. If you have it, feel free to share it. It has to do with, I just don't have it right in front of me, the actual definition of an establishment, but certainly for our purposes, we're using that as an address. The issue of the California teleworkers is a big question that's been coming up. So if you have employees who telework from California to another location, even though it's not in California, you would be including them. That's the Nevada example, I think, that we gave. So that would be a reporting obligation. Another question that was coming up quite a bit was, what does it mean to be assigned? Are we talking about you're assigned to, like, are you reporting to someone? So maybe the employee doesn't, sits outside of California, but their manager sits in California. You got take a look at what the requirements provide, and take a look at how you define reporting to. So if you've got somebody who physically is sitting outside of California, I wouldn't worry about those people where they're unless they actually report to a location. So you've got to take a closer look at that reporting obligation. It's not to a manager, it's to a specific location. So you've got them in your data reporting to another location, and that location is in California, then you are going to want to report on those, and the reverse is true. So you've got teleworkers in California, but they report out, or, well, if they sit in a California location, obviously you would be reporting them as well.
I have put my hands on that definition of establishment.
Thank you.
Although I think our way of thinking of it is probably more clear for instruction purposes. So an establishment is an economic unit producing goods or services, is how California defines it.
Yeah.
So I think thinking of it as an address is probably an easier and more administrable way to think about establishment.
I want to reiterate also, there's a question that came up about the reporting, the parent company reporting issue. So the question said, this seems to contradict reporting requirements for parent company reporting. Is this a company by company reporting or everyone lumped together? So we mentioned this in the beginning of the call that we think that this is a big difference, and we're trying to get clarification on this as quickly as possible. And when we do, we'll provide that if we get it. But the way it appears to us is that the guidance from California is quite different. It specifically refers to each pay reporting requiring or being filed for a, quote, single employer. And then when you look at the reports themselves and how they're set up and who you have to report, it appears that each report with the employee level information is only as to a single, employer that has a single FEIN number. So it appears to us that this is going to be very different, and it would be a separate filing company by company, even if they're part of an overall enterprise, which is very different from EEO-1. So I just want to caveat that that's how it reads to us. We're certainly trying to get more information because it's not as explicit as we certainly would like it to be. There's questions about whether there's a distinction with regard to several business units under the same umbrella. It's not clear what that means. If you're talking about divisions of a company, assuming they have the same FEIN number and they're the same employer, I would say that you'd be filing one report. If by business units you're referring to, completely different FEINs or employers, then yes, I believe based on my prior comments, that it would be separate. We're getting lots of questions about whether the webinar will be recorded and if the deck is going to be available. And yes, everybody will get copies of both the recording and the slides as well.
And the copy that we send out, we will have the contact info for myself, for Annette, and for Sharday. So as questions come up, please don't hesitate to reach out to us. This is a lot of complicated information. It's coming at us very fast and on a very short time frame. And again, we don't want you to waste any time in kind of getting your ducks in a row and starting to get this all together.
Yeah. One question that came up was about race, ethnicity. I don't recall, if employees don't respond. I know under EEO-1, you have a requirement to do a visual or to provide that information based on other records if, an employee chooses not to respond. Mike, do you recall, or Sharday, do you recall if either one of those are specifically called out, if that guidance is specifically called out in California? I don't recall that being the case.
It's not specifically called out in California, though by induction it is called out because your obligation to file is tied to whether or not you have an obligation to file the EEO-1. If you have an obligation to file the EEO-1, you have the obligation to do the visual. So transitively, you have an obligation to do a visual in California as well.
Okay. Okay. Let's see. Are there other questions that you guys are seeing? I mean, there's a ton of questions here. In terms of the value to California, it's going to be interesting to see what they're actually able to do with this information or how they're going to be able to gather the information. Potentially, if there's a specific complaint that comes up, perhaps they can take a closer look at the information that's filed on an EEO-1. Certainly, I think there are other ways to obtain that information. So we'll see what they're actually going to be able to do with it. I don't think it's going to be super relevant to actually to real understanding compensation for a particular organization.
Yeah, so we have gotten a couple of questions about so the number of locations or certain locations within California that I have. I had during the reporting period, but I've closed those locations since January 1 or at least before March 31st. Do I have to report on those locations? And according to the state of California, yes, you would still need to report for those locations, even though they are no longer open because they were open during the reporting period. And I think I accidentally cut Sade
questions. That's okay. There's also a few questions of employers who have employees who are assigned to a location outside of California, but 5 to 10 of them are working remotely from their homes in California. What address to use? You should not use their home address. You should be using the address for that location that they're assigned to outside of the state of California, since they are working remotely from the state of California.
Yeah, and that's going to follow that example that Sade gave you about the employee who's in Nevada. So assume instead of driving across state lines from his home in California to the facility in Nevada, he just remoted in to the facility in Nevada from his home in California. You would report him either way at that facility in Nevada because he has the ties to California by virtue of living there, but his actual company facility is the one in Nevada.
A couple more questions that I think are really important. This is a California-only requirement. We've been talking about EEO-1 quite a bit. There's still going to be a separate EEO-1 filing, so this is not going to take the place of the EEO-1 report. So that the portal's not open yet. They said that it's probably going to open. I think they said in March or April. So you're still going to have a separate reporting obligation. Let's talk about that reporting period and the snapshot, just so that we're really clear about that. The 10/1 to December 31 date, right? You just select a time period, and I'm going to use November 1st as the payroll period that you selected. All that does is tell you these are the employees I'm going to report on. So even if you selected a November date, you're going to wait until the W-2 information is done, right? Year end, that's what you're reporting on. You're reporting on the entire wages and hours, those employees that were on your snapshot that you selected. So November, if that's what you pick, and you can pick whatever you want. But you're going to report on all those employees that were on that snapshot period, and you're going to include their data for the entirety of the year. So full wages and hours worked for that time period. So that's another important distinction.
So we got we're getting a couple of questions about if my company is structured in such a way that there is a controlling establishment within California that has sub-establishments that report to it, would you roll those into a single report? Based on our understanding, no, you would not. Each one of those kind of separate physical locations, separate physical addresses would be its own report. And this is similarly going to, at least in our mind, apply to kind of campus or nearby location situations. So if you have 4 retail stores that are very close to each other, those are 4 separate reports, as far as we understand, not just rolled into one report covering all 4 locations.
Yep. Just another question here on the 100 threshold. For purposes of that, looking to whether or not you've met the 100 employee threshold, you would be considering all your employees, not just those in the state of California. So if you have states outside of, employees outside of the state of California, you're looking across the U.S. For purposes of that 100-person threshold. I think that is going to do it. I think we've tried at least to capture most of the the key questions. We were getting a lot of them that are based on the same issues. We'll take a closer look at the questions that you have provided, and we'll do our best to kind of create a summary and push that out to you all as well, because this really is a lot of incredible lot of information that you're going to be gathering and capturing under very, very short time periods in terms of, this being due on March 31st. So please reach out, let us know how we can help. We will keep updated on the information that's out here. We've provided the website that has the information, which is showing up on your screen right now. And it's got some basic information so that you can get the link. Make sure you get the FAQs. Again, we will provide the deck along with the webinar materials. Thank you so much for joining the session today.
This concludes today's webinar. Thank you for attending.